Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, I wanted to talk about this case like the day it came out, but we had something else going on. What was? Oh yeah, it was an election, okay? And then there was the big to-do about the election, and everyone's attention just kind of turned that direction, which I completely understand. We even turned our channel's direction that way as well. But I do want to circle back on a really important case. It comes out of Colorado, and it's a really, really important case because it's a disappointing ruling, but it's a much scarier ruling than that. And so I think all of us need to be aware of it, because if you're living in one of those states that, likes to take your guns, this line of reasoning could easily be shoved down your throats. It's a classic example of, they will take a molehill and turn it into a mountain. If you give them an inch, they will take a mile. They will hang their hat on just about anything, or whatever other metaphor you can come up with. So today, let's spend a few minutes and let's talk about a very dangerous precedent that could disarm millions. Why in the year 2024 should anybody even think about having self-defense protection? Because, 25 years ago, we would have never had this conversation. So what's different today?
Bill, we really saw a need a number of years ago when the volatility and divisiveness of our country started to change drastically. And we, by the way, are gun people protecting gun people. We
Right.
come from a significant gun background.
Right to bear, that's right. Legal protection for self-protection. Listen, good lawyers aren't cheap. Cheap lawyers aren't good. You're not truly prepared unless you have right to bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com. Okay, this case has kind of flown under the radar, and I kind of want to bring it to everyone's attention. Okay, now, by the way, this information was all disseminated by Miss Hannah Hill over at the National Association for Gun Rights. Now, listen, we're always trying to tell everyone around here, hey, you need to be educated. You need to know what's going on. If you want to know about the mountains and mountains of litigation that NAGR is engaged in, well, then why don't you give her a follow right there on X, okay, at HannahHill_SC. She does an absolutely fantastic job of getting everyone tuned in. Okay, now, the case we're talking about today is a case called Rocky Mountain Gun Owners v. Polis. Follow me, if you will, because I want you to understand procedurally what happened here. Okay, on April 28th of 2023, Governor Polis signs a new law, which is actually Senate Bill 23-169. That law is set to be enacted on August 7th of 2023. It would now restrict the age of purchase for all firearms, not just certain platforms of firearms, but all firearms inside the state of Colorado to anybody who's 21 and older. So if you're in that horrible age of legal purgatory, 18, 19, or 20, you would literally not be able to buy any firearm inside the state of Colorado. Washington State is not even that screwed up yet. Okay, Rocky Mountain Gun Owners files a lawsuit. They request an injunction. The court grants the injunction on August 7th, the day the law was supposed to go into effect. So away we go. The law has not yet been enforced against Colorado until recently. And, of course, the state of Colorado craps its pants and immediately appeals to the 10th Circuit. So what we have here is an appeal in an interlocutory fashion, or basically, put in simple terms, we are appealing this game sometime in the second quarter of the football game, okay? So since we're appealing injunctive relief, we got to go back, geek out on that for a second. How do we get an injunction? Well, in simple terms, the plaintiff has to show, one, they're going to suffer irreparable harm, and number two, that they are likely to prevail on the merits. Obviously, the lower court found exactly that. However, the state of Colorado now comes before the 10th Circuit with the following arguments. One, the named plaintiffs, Musgrove and Pineda, don't have standing. That's right, there are two named plaintiffs. You actually need individuals, and these individuals would be people who are 18, 19, or 20 years old inside the state of Colorado who presumably wanted to purchase a firearm and had declared under penalty of perjury to such. All right, now, you know what happens anytime they're arguing standing, right? It tells you just how strong the state of Colorado feels about the position, right? Now, here's their other argument. Two, the Second Amendment's plain text does not cover plaintiffs until they are age 21. That's right, they are actually saying you don't become part of the people until you are age 21. What else? The age restriction is presumptively lawful. Okay, I want you to remember that one. Presumptively lawful. What is that? 4, the age restriction is consistent with this nation's historical traditions. And finally, plaintiffs cannot satisfy all the factors for an injunction. Okay, so the court tears through the first two Colorado arguments pretty easily, including the kind of absurd one that, you're not part of the people until you become age 21. However, we get to this third one where the law is presumptively lawful. And we go, whoa, wait a second. I geek out on this channel a lot. I geek out on other channels a lot too. What is this presumptively lawful standard? Here we go. This is where the danger begins because the court finds the Supreme Court has identified several types of firearm regulations as presumptively lawful. Okay, and if you look at the citation, it's not directly from Heller, it's from footnote number 26 in Heller. And then it lists several types of gun restrictions which are presumptively lawful. 5 of them to be exact. The one that's applicable here states 4, laws imposing conditions and qualifications on the commercial sale of arms. And then in some fashion, that language has appeared all the way back in McDonald, all the way up through Bruin, and so therefore, the 10th Circuit decides, so when it came to the statement and restatement that there are presumptively lawful firearms regulations under the Second Amendment from Heller to McDonald to Bruin, our high court went 3 for 3. And then Justice Kavanaugh in Rahimi also included some of that language in his concurring opinion. Okay, so here we are now, 4 for 4. And with that, the court then rules, because the presumptively lawful regulatory measures language first stated in Heller has not been abrogated, it remains good law. Yeah, but it's dicta, right? It's not actual holdings in the case. And as we know, courts that are hell-bent on civilian disarmament will ignore rules of law, and they most definitely will ignore dicta. So why is the court hanging its hat on it? Well, because apparently in this instance, they believe, and even if it is dicta, we are bound by the Supreme Court dicta almost as firmly as by the court's outright holdings, particularly when the dicta is recent and not enfeebled by later statements. Well, I can assure you that the court has made far more pronounced statements than that as it relates to Second Amendment rights, and yet you guys seem to keep missing the memos on that one. The dangerous ruling, though, that this whole line of reasoning leads us to, and this is what I want everyone to be aware of right here, is this holding right here. We hold that as an age-based condition or qualification on the sale of arms, SB 23-169 is covered by the safe harbor and as such falls outside the scope of the Second Amendment's right to keep and bear arms. Why is that, you say? Yeah, because the state apparently, according to the 10th Circuit, has unfettered ability to regulate the commercial sales of arms. And the reasoning they use is as follows. The plaintiff's challenge centers on their role in the transaction, specifically their intention to purchase a firearm. Both actions, selling and purchasing, are dependent upon the other. That is, there can be no sale if there is no purchase. Pineda argues the right to keep and bear arms implies the right to acquire. An excellent argument, by the way, one that is actually supported by case law as well as, common sense. But then the 10th Circuit finds, but the contrary is also true. A presumption that laws imposing conditions and qualifications on the commercial sale of arms are lawful extends equally to laws imposing conditions and qualifications on the commercial purchase of arms. And there you have it. There you have it. That is exactly how they believe that now a state has completely unfettered discretion in placing restrictions on the commercial sale or purchase of firearms. And who do they cite as one of the great reasons? Oh yeah, you know it's getting scary when the Ninth Circuit is being cited. As the Ninth Circuit noted, the most reasonable interpretation of that passage, carving out presumptively lawful regulatory measures, is that commercial restrictions presumptively do not implicate the plain text of the Second Amendment at the first step of the Bruin test. So even though the court goes through pages and pages here of just discombobulating and confusing the Bruin test, what this ruling actually allows them to do is to apply no Bruin test at all. Okay? Don't believe me? Well, this is exactly what the court said. Perhaps most importantly, it seems inconsistent to conclude that step one is a textual analysis and then take an expansive view of the text to infer concomitant rights that are not present in the language of the Second Amendment. Rather, the best reading is that SB 23-169 is presumptively lawful because the age-based condition or qualification on the conduct it prescribes falls outside the scope of the plain text of the Second Amendment. That's right. The court is finding that the ability to acquire a firearm for a person 18, 19, or 20 falls outside the scope of the Second Amendment because the law is presumptively lawful based upon dicta that's been in other cases to restrict the commercial sale of firearms. And if it restricts the commercial sale, it obviously means there's unfettered discretion for the commercial purchase. That is the holdings in a nutshell. And even if you think that this law somehow or another is discriminatory in nature, the 10th Circuit disagrees because they literally are using the term safe harbor. If the law is presumptively lawful, it lies within a Second Amendment safe harbor. I'm not joking. The court ruled, we agree and hold that SB 23-169 does not employ abusive ends that would disqualify it from the presumption of lawfulness. So you sit there and you go, let me get this straight. An 18-year-old who could move out of his parents' home, sign a lease, purchase a home if he was financially capable, purchase a car, sign the contract, join the military, vote, go get a tattoo, any of those things is not mature enough to own a firearm. And I would point out for people who argue into issues that are way outside of Washington gun laws lane, so we're not going to get there. But that argument, if true, doesn't seem to jive with other arguments that seem to come from more progressive causes. In fact, the 10th Circuit bought off on it as follows. Third, we reject the notion that the minimum age for purchasing a firearm should automatically mirror the minimum voting age. By its plain text, the Constitution does not establish a one-age-fits-all standard for all rights. Age does not establish a one-size-fits-all for constitutional rights. Just think what other courts could do with language like that. And it's for that exact reason that we call this a very dangerous precedent that could in fact disarm millions. Okay, the case once again is Rocky Mountain Gun Owners v. Polis. We're going to link it up down below. The National Association for Gun Rights heavily involved in this case. We're going to go ahead and link them up down below so you can show them some love. We're going to put Hannah Hill's contact information down below so you could link up with her and get up-to-date information on all of the fantastic litigation that the good folks over at NAGR are doing. If you got any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's down in the description box. If you got an idea for a video we should be doing around here, cool, let's hear about it. Click on that link right there. Let us know. If you want to subscribe to our monthly newsletter, all the ability to do that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.